With your due permission, sir, may we start the session? Thank you, sir. Hearty greetings to one and all. Myself, Japji Khurana, Head Student Organizer of Department of Law, Government Mahindra College, and it gives me immense warmth and great pleasure to grace your presence in the interest of the entire department to the 5th National Webinar organized by Department of Law, Government Mahindra College. It gives me tremendous contentment to accord my hearty welcome and warm regards to our honored dignitary, who have won accolades in legal fields, our esteemed keynote speaker, Shri Gurnoor Singh Sandhu, Advocate Punjab and Haryana High Court. We welcome you, sir. I would like to thank you for honoring our invitation. We are so privileged and honored to have such great legal luminary present with us today. Thank you so much for sparing your valuable time and gracing this event with your presence. Let's now welcome the personality who doesn't need any introduction and is known among all of us for her wisdom, knowledge, our Honorable Principal Ma'am, Dr. Simrat Kaur. We are really grateful to you, ma'am. This event could not have been possible without your dynamic guidance and support. We welcome you, ma'am. My special welcome and gratitude to Head of Department of Law, Dr. Joginder Paul, and Teacher in Charge, Dr. Sanjeev Mehta. We welcome you, sir. Now, I would like to welcome our wings of light, our pillars of strength, our constant source of motivation, that is, Revered Faculty of Department of Law. Dr. Sukhdeep Kaur ma'am, Professor Gurjeet Kaur ma'am, Dr. Harpreet Kaur ma'am, Professor Rishabh Jain sir, Professor Rajveer Kaur ma'am, Professor Saman Devgan sir, and Professor Angad Jodhpal sir. It is due to their continuous moral support and guidance that we could successfully handle such various virtual sessions. Department of Law, Government Mahindra College is known for its legacy and excellence. Our college has covered a long journey of 140 years in a regal style, bolstered by untiring efforts of teaching faculty, scintillating achievements of its alumni in all fields of human activity. Our college was awarded with A grade by NAC in February 2016, highest score given to any college in the country. We are known to make the best out of the worst situations. Even in the tough times of COVID-19 pandemic, with the collective efforts of the management, faculty members, and the student, our department reached the epitome of excellence by organizing more than 10 various national level events. Not taking much of your time, I would like to hand over the mic to our teacher in charge, Dr. Sanjeev Mehta.
A very good morning to all. I welcome our worthy speaker of today's webinar, Shri Gurnoor Singh Sandhu, Advocate, Punjab and Haryana High Court, Chandigarh. I also welcome our Principal Ma'am, Dr. Simrat Kaur ji, our HOD Sir, Dr. Joginder Paul ji, faculty member of different institutions, member of legal fraternity, my worthy colleagues and dear students. I feel honored in giving welcome speech on behalf of the Law Department and Government Mahindra College, Patiala. I convey my heartily welcome to our worthy speaker, Advocate Gurnoor Singh Sandhu. Welcome, sir. Now, I immensely pleased to introduce our speaker, Gurnoor sir. He has completed his law degree from Army Institute of Law, Mohali. He secured O grade in certificate course on applied criminal law and procedure organized by the Gujarat National Law University, Gandhinagar, Gujarat. He secured first position in Chandigarh United Nations Association Entrepreneurship Competition 2013. He has adjudged as the best speaker in the Surana and Surana Trial Advocacy Competition 2015. He was the winner of the second best judgment entry at the Surana and Surana Judgment Writing Competition 2015. At present, he is practicing as an advocate in Punjab and Haryana High Court, Chandigarh. I hope that succeeding session would be very meaningful and envisioning for our listeners. I again convey my gratitude to him for sparing time for us and gracing the occasion. Thank you, sir. Now, I request Gurnoor sir to please come and deliver his lecture. Gurnoor sir.
Thank you, sir, for such a lovely introduction. I'm extremely thankful for the same. I must express my heartfelt gratitude to the college authorities, including Madam Principal, the faculty and students, for giving me an opportunity to express my views on the topic for today's discussion, that is service law vis-a-vis departmental proceedings and procedure. So, first of all, I would just like to state in few words as to why I picked up this topic for today's discussion. See, the reason for picking up this topic is that as a law student, the subject of service law is never taught in the curriculum. And when we start going to the courts for our internships and court proceedings, we cannot fathom with as to what is happening in the courts when such cases are taken up. So I particularly faced this problem because the senior with whom I'm working, Mr. Gurnoor Singh, he's been a keynote speaker in one of your national seminars. He is a master of service laws. So when I joined Sir's office as an intern, I could not understand anything about service laws. So therefore, I thought when I was requested to deliver a keynote, I thought it would be better to speak on something that is not part of our curriculum so that the problem that I faced is not faced by other students who wish to pursue litigation or who wish to become public officers, so that they would know what service law is. So now coming to the topic. Before coming to our core topic for today's discussion, that is departmental inquiries, I would just like to explain what is service law. See, when somebody gets employed with an employer, say in a corporate firm or a business house, MNC, even faculty members of your worthy college, they are governed by a contract, and there are terms and conditions of those contracts which the employer and the employee is required to follow. And if there is any breach of those terms, they can take action as per the contract. Similarly, when a public servant gets appointed through a public service commission, it is to be noted that in a government, the public service commission makes appointments. So if it is a state, it will be the state public service commission, and if it is the services of a union, it will be the union public service commission. So when a person gets employed through these public service commissions, he is also governed by certain terms and conditions. But these terms and conditions are not merely contained in his order of appointment, they are contained in certain statutory rules and regulations, which have the force of law, which have been duly notified by the legislature. These rules and regulations are called service laws. So to cite a few, we have the Punjab Civil Services rules, which govern the services of the people who are employed in the Punjab Civil Services. Then we have the Central Civil Services rules, and so on and so forth. So when these rules are and these laws are, when they are taken collectively on face of it, they are called service laws. So this is, I'm sure I've been able to define what service laws are in as brief as possible, because this will help us to understand the main topic for today, that is departmental inquiries. So now coming to the question of departmental inquiries. What are departmental inquiries? See, when we talk about the phrase public servant, we specifically use the word servant and not an officer. One must think that why are we using the word servant? Because we public servants are the servants of the public. They are supposed to work for the public, they are supposed to work for their welfare and their better interests. So therefore, whenever any government servant fails to perform his duty in the best interest of the public, of the general people, he can be duly proceeded against by the department. And this is when the departmental inquiries come in. This is the first one. Second is, if a person is performing his duties as a public servant and he is not able to safeguard the interests of the department in which he is working. For example, if a person is indulging in acts of corruption, he is indulging in acts of money laundering, he is causing loss to the state exchequer, in that case, the department can also proceed against him, and the manner and the mechanism which the department will resort to proceed against him is the procedure of departmental inquiries, which we will be discussing in detail. So this is the need. Basically, it is there to discipline the officers and set example that in the coming times, the services are purified and all the delinquent officers who are not performing their duty properly are chucked out from service, and the services, their dignities are maintained as they are required to be. So now, once we talk about the department or the government's power to take disciplinary proceedings against the public servants, they have two kinds of powers. First is that if, say, an employee is indulging in acts of corruption, they can simply file a complaint with the police or the Vigilance Bureau or the Enforcement Directorate, and they will register an FIR under the Prevention of Corruption Act or the Prevention of Money Laundering Act, respectively. And they will let them do their due proceedings. On the same hand, the department will also initiate disciplinary proceedings and departmental inquiry against the person to find out whether the act alleged against him is correct or not. Now, at this stage, I'm sure all the listeners and all the participants must be wondering that Article 20 subclause 2 provides that no person can be punished for the same set of allegations twice. So if here the government has the power to also file a complaint with the police or the Vigilance Bureau and also has the power to start its own disciplinary proceedings, then it may result in violation of the provisions of Article 20 subclause 2 that says that there should be no double jeopardy. However, the Honorable Supreme Court, the Honorable Supreme Court has in plethora of judgments clarified this very legal issue, and they have stated that criminal prosecution against a public servant and departmental proceedings against him can be continued in a parallel manner and on the same time. So, for example, if the person who is a public servant who is being prosecuted in the court of law, in a criminal court, is, say, convicted for the acts of corruption or for the acts of money laundering, there is no bar for the departmental inquiry to also hold him guilty for whatever wrong he has done. So basically, Article 22 will not hit parallel criminal prosecution and departmental inquiries. So this is a very, very vital topic, subtopic which I touched upon at the very beginning, because then if I would have started straight away with departmental inquiries, one would always think that what about the criminal case? So both of them can go back. Now let's see, in order to stress upon the importance of these departmental inquiries, we need to go to the law of our land, that is Constitution of India. Article 311 of the Constitution of India clearly provides that if the state or the union government proposes to dismiss, remove or reduce in rank any person who's been appointed in a civil capacity, which will be a public servant, they cannot do so without holding a proper inquiry in which the charges against him will be proved and a fair opportunity of hearing will be given to him. So if all of this is done, then they are free to inflict any punishment. So why I am stating Article 311? I'm stating it because I need to lay stress and importance on the fact that the origin and the foundation of departmental inquiries lies in our law of land, that is the Constitution of India. So it is not merely the service laws where it is provided. It comes from the law of our land, that is Constitution of India. So I'm sure I must have been able to lay a good foundation for us to move to the next stage of my keynote. That is, what are the stages of departmental inquiry? See, at the very outset, the departmental inquiry is preceded by a few stages and proceeded by a few stages. And departmental inquiry lies in the middle. And those stages I'm just going to discuss. So first, now let's take an example that, say, a public servant is working in the Punjab Electricity Board. And somebody files a complaint against him that he has waived off somebody's electricity bill in an illegal manner. So that complaint will be filed in his department, that is the electricity board. Now, once that complaint is received, the department is not going to initiate a departmental proceeding straight away. Why so? Now, in our country, there are certain strict officers. There are certain officers who do not pay heed to any kind of influence being exerted by them, by the political heads. So what happens is that there is always this scope of malafide and vindictiveness against the employees who are doing their duty correctly without submitting themselves to any kind of pressure. So once such kind of a complaint is received, the department will always carry out a fact-finding inquiry or a preliminary inquiry to find out whether the allegation made out in the complaint makes a prima facie case or not. Because as I said, that if a person is totally honest, he is working as per his duties and doing everything but not submitting to the political pressure, the political heads may move false complaints against him. So in order to check that, the department will not start the disciplinary proceedings straight away. They will first hold a preliminary inquiry. Now, what is a preliminary inquiry? Preliminary inquiry is a very basic fact-finding inquiry in which they will peruse the contents of the report or the complaint or the allegations, and they will see whether they are frivolous or whether they have some substance in it. They will not give any final opinion whether the person is guilty or not, because it's a preliminary inquiry. And something very important to note at this stage is that the person against whom that complaint is made has no right to be heard at this stage, that is the stage of preliminary inquiry. He has no right to be heard. There is no opportunity of hearing given to him at this stage. So once the officer, it's usually a senior officer of the department who was appointed. So let's coming back to our example of that person in the electricity board or complaint was filed against him. So the preliminary inquiry officer finds that there is a prima facie case. He did help somebody to waive off his bill in an illegal manner. So the preliminary inquiry officer will give his findings and he will say that a full-fledged departmental inquiry is required to be conducted. Now, in this case, once his recommendation is there on record, the second step in the stages of departmental inquiry, this is also a pre-stage, that is serving of the charge sheet. Now, we must all be aware of the fact that all the students, especially, that the concept of charge sheet is also taught to us in criminal laws. So, the charge sheet which is presented to the delinquent officer against whom the departmental inquiry is sought to be initiated is somewhat similar to a charge sheet that is given in criminal law. So, it contains the statement of charges in a chronological manner, say 1, 2, 3. For instance, in the example that we picked up in the very beginning, that is a person in the electricity department helping somebody waive off his electricity bill in an illegal manner. So in that case, the charge will be that you, the delinquent officer, has helped so-and-so to waive off his electricity bill in an illegal manner. And there could be more charges also. So this is the statement of charge. It's a 2-line, 3-line statement in chronological order, depending on the number of charges. Then along with the charge sheet, there's a statement of allegation. This statement of allegation is more detailed. It contains the sum and substance of the case which the department sought to proceed against the officer. So these are the two main things that we find in the charge sheet. It is also called as the memo of charge. Now, since I've told you that the process of departmental inquiries, it's a quasi-judicial process. So since it is quasi-judicial, it bears resemblance with the procedure that is followed in a trial, in a criminal trial. All the students and respected faculty members would be well aware that how a trial takes place. So similarly, even in a departmental inquiry, the basics of a trial can be seen. However, it's very, very important, that thing that we should always remember. The burden of proof is not the same. So in a departmental inquiry, the burden of proof is much, much lesser. It is mere preponderance of probabilities. Whereas in a criminal trial, the burden of proof is beyond reasonable doubt. And coming back to my very initial statements that I made in the keynote, that both criminal and departmental inquiries can go hand in hand. This is the very reason why they can go hand in hand, because the burden of proof in both are different. So you might get acquitted. In a criminal case that will have no bearing in your departmental proceedings, and vice versa. So this is it. So once you are served the charge sheet, you will also be served a list of witnesses who wish to depose against you in the departmental inquiry, you will also be given, the delinquent officer will be given the list of documents that are sought to be proved against him. And he will also be given an opportunity to examine the documents. Now this element, as lawyers, I must say, the opportunity to examine documents and the list of witnesses, these are the lacunas which we find. Because when a public, for example, this very public servant that we have hypothetically taken to be a person who is in the electricity board, for example, if he approaches me at this stage, that sir, I am caught up in a departmental inquiry, you help me. As a lawyer, I will just have a glance at the charge sheet and I will ask him whether he has been provided all the documents or not, whether he has been given the list of witnesses or not, whether he has been given an opportunity to examine the documents in physical form or not. And if the department has not done so, as a lawyer, I will straight away file a writ petition in the High Court and get these proceedings stayed until and unless he is given a due opportunity to examine the documents. So these are the lacunas that we as lawyers find out. So once the charge sheet is there, we are done with two stages now. We are done with the stage of preliminary inquiry and we are done with the stage of serving of the charge sheet. Now once this is done, for the first time now, the delinquent employee will be given an opportunity of hearing. He will be given an opportunity to submit his written defense before the full-fledged departmental inquiry starts. Now in this written defense, the delinquent employee will state as to why these allegations are false, why these allegations are not made out, and then he will support documents just like any written defense that we file in courts. He will just file it in a similar manner. And he will say that I am not guilty. Coming to our example, he will say that I have not waived off this electricity bill illegally. I have done so as per the rules. I have done so as per the provisions. I am not to be proceeded against. So once he gives his written defense, then the same will be considered by the department. And if upon considering his written defense, the department feels that there is no requirement for a departmental inquiry, they will drop the charges. But if they feel that no, his written defense is not sufficient, the reply given therein is not sufficient, they will recommend a departmental inquiry. So now at this stage, so now we are done with three stages. Now if the defense is not considered, now comes the stage of departmental inquiry. That is the main topic for this keynote. So these were the pre-stages, now comes the departmental inquiry. So the departmental inquiry is, as I told you, it is just similar to a trial. So it is headed by a adjudicator. There is a officer who will present the department, just like an advocate presenting the prosecution. There will be the delinquent employee, his legal representation. So it's just similar to a court setup, although in a quasi-judicial capacity. So the inquiry officer who is heading the departmental inquiry as an adjudicator is expected to be a non-interested party. And by non-interested party, I mean that he should not be somebody who was either concerned with the department or who would want this person to be punished. So he has to be an independent person. Again, here as lawyers, as I stated earlier, here again we step in. So for instance, this very person who we've hypothetically taken the example of, if he comes to me as a lawyer, I will tell him that yes, your inquiry officer seems to be a person of the department and he cannot adjudicate this matter free of any kind of influence, so we'll move to the court. So we'll straight away move to the court at this stage also. The court will consider it, we will state the grounds as to why this person, then they might order changing of the inquiry officer also. So this is another lacuna which we as lawyers we catch them. So once the inquiry begins, the inquiry officer is legally entitled to issue summons. He is entitled to examine witnesses and call for documents. Just like a civil court, he will do that. Now, very interesting part. The inquiry officer, just like a judge of the criminal trial, he does not have the power to inflict punishment. Here lies the difference. He can only, after the inquiry is conducted, after the witnesses are heard, cross-examination is done, the statements are recorded, documents are taken on record, he does not have the power to inflict a punishment. Because that power lies with the punishing authority. So what the inquiry officer can do is, he can merely state in detailed reasons as to why these charges are made out against the delinquent employee, or why not the charges are made. So he can either give a favorable finding or a finding against the employee, but he can never order infliction of a punishment. So when it comes to infliction of a punishment, we come to the fifth stage, that is the punishing authority. So what happens is, once the inquiry officer has given his judgment, if I can say so, it's basically called an inquiry report, but for common understanding, we can say that he's given his judgment. So once he's given his judgment, the punishing authority steps in. Now what happens is that there are two kinds of punishments that are provided in the service laws. For example, if talking about the state of Punjab, there's Punjab Civil Services Punishment and Appeal Rules 1970. So Rule 5 of those rules provides two kinds of punishments. One are minor punishments, second are major punishments. So minor punishment could be a censure, warning, etc. And major punishments are removal, termination, withholding of increments or reduction in rank. Now as students of law, you must be thinking under this head of major punishment as to what is the difference between removal and termination. Because for a common person, a layman, the words removal and termination seem to be synonymous. But no, as per the service laws, the term removal and termination are different. How? I will explain. See, when a person is terminated from service, he will not get any benefit, any retirement benefit, pension, nothing. He will be stripped off of all the benefits that he would have got if he would have retired. He will not get any. But if a person is removed from service, he may get some retirement benefits, not all of them, but he will get some of them. So this is the underlying difference between the term removal and termination when it comes to service law. So now coming back to the role of the punishing authority. So once the inquiry report is placed before the punishing authority will call for another explanation from the delinquent employee against whom the inquiry is being carried out. He will call for his explanation to seek the answer as to why this punishment should not be inflicted on him. At this stage, the employee will again give his explanation that, sir, I have been falsely implicated, the procedure has not been followed correctly, this is not a case of case where you can inflict a major penalty, or this is not a case where you can inflict minor penalty, so on and so forth. As anybody would give his defense, they will give their defense. After considering the defense, the punishing authority will finally pass an order of inflicting the penalty. That penalty could be a major penalty, that penalty could be a minor penalty. So this is the state. Now once assume the person is the person has been imposed a penalty, may it be a major or minor. See, that causes a stigma on his service. That will affect his promotion, that will affect his seniority, and if he is terminated, then everything is gone. Then nothing remains. So it is a major stigma. And you guys will agree with me that, as being law students also, if you are thrown out of service by termination or by removal, no other employer would like to keep you. So it's a major stigma. So what does one do? If somebody is, if I can use the word, convicted by the punishing authority, what will he do? Then there comes the provision of appeal. It is a departmental appeal which is provided. It is not an appeal before any court. It is a departmental appeal. So this employee who has been convicted will file an appeal before the appellant authority. The appellant authority will not reassess the matter as if it were the inquiry officer or the punishing authority. It will see whether everything has been duly appreciated, all the evidence has been duly taken into consideration, just as appeal works, right? So the right to file appeal against the order of imposing penalty is provided in the rules itself. So if it is not provided in the rules, then I will come to the next step. That is where again as lawyers we step in. So if it is not so, then we can directly file a writ petition in the High Court and we can challenge this order on whatever grounds are relevant to the particular employee's case. So even if there is no appeal, the person is not rendered helpless. He can still come to the courts. We are there for their service. Now these are the stages. In sum and substance, if I can just quickly go through these stages again. The first stage is holding of preliminary inquiry. Second is serving of the charge sheet. Third is filing of the written defense by the officer. Fourth is the full-fledged inquiry, the departmental inquiry. Fifth is the role of the punishing authority to inflict the punishment. And lastly is the appeal or coming to the court. These are the stages. Now what happens is, the underlying principle which has to be followed regardless of the rules, whether it is there in it or not, is the principle of natural justice. So being students of administrative law, I'm sure administrative law would be taught in your college. If I go back to my college days, I remember we were taught 6 kinds of biases. So even administrative law recognizes the concept of bias. So therefore, the principles of natural justice have to be followed in these inquiries. And if there is any element of bias, that can be a psychological bias, that can be an institutional bias. I'm not able to recall all the 6 kinds that I was taught, but these are the ones that are used mostly. So if there is any of these bias, the entire inquiry can go away. Because the first and foremost principle which is pertinent to be applied at all these stages is the principle of natural justice, that a fair opportunity of hearing should be given. The person should be heard, all the documents should be considered. So natural justice can never be given a go-ahead. It has to be followed. So now, since I've just talked about the fact that the lawyers challenge these orders passed by the punishing authority in the court, one must also know that the court will never sit and appeal over the order passed by the inquiry officer. The court will only see whether the decision-making process is legal or not. And by the decision-making process, I mean that whether all these 6 stages that we have discussed have been followed while inflicting the punishment or not. So for instance, if there is no preliminary inquiry, or for instance, there is no hearing or no opportunity given to the employer to file his written defense, then we can move to the court and we can say that the decision-making process is bad in this case. They have not followed the correct decision-making process which should have been followed, and therefore this inquiry needs to be set aside. So the courts interfere in those cases. They set aside the inquiry. They can remand the matter for fresh appraisal, or they can also exonerate if the facts are so much in favor. If the inquiry is vested with mala fides, vindictiveness, then they can also order the setting aside of the entire inquiry and exoneration of the employee. But that's in very rare cases. The court will never do that. Very rare cases. So now you must be wondering if you are paying attention to this lecture, what happens to the delinquent employee while all these stages are being carried out? Whether he's paid his due salary, or he's not paid his salary while he's being prosecuted in the departmental inquiry. So here comes the question of suspension. I have kept it at the later end specifically because this is very, very important. Because the power of suspension, as I in the very beginning, I have stated that these officers are always subject to the whims and fancies of the political heads. So these political heads, they misuse these service laws to exert pressure on those public servants who are not working as per their tone or as per their orders. So what usually happens is that the power of suspension is also vastly misused, where if a person is on a key position, public servant is on a key position, and he is not working as per the directions of the political heads, they will make sure that he is placed under suspension. So we need to understand that what is the correct manner of utilizing the power of suspension of an employee against whom some kind of a case is pending or these disciplinary inquiries are pending. Excuse me. See, at the very outset, suspension is not a punishment. So if, say, I am, as a public servant, I am placed under suspension, it is not a punishment. It is a stopgap arrangement. It is an interim measure to make sure that the delinquent employee does not interfere with the departmental proceedings which are being carried out against him by maneuvering the witnesses, by maneuvering the records or manipulating the records in his favor. So it is just a measure to keep him out of the department until and unless the departmental inquiry is not completed. So just to make things interesting, I would like to connect the power of suspension with that of bail. So take an example that person is, say, charged, he's named in an FIR under section 307, wherein he tried to shoot at somebody, but the bullet missed him and he did not die. So therefore 307 is sought to be prosecuted against him. Now when we move to the court, why I'm giving this example is because most of the law students would be able to understand this in better detail because they would have studied criminal laws. So when we move to the court for seeking bail, the court will consider whether giving me bail will affect the trial or not, or will affect the witnesses or not. So if the court comes to a conclusion that if I am given a bail, I will go and maneuver the witnesses, I will try to threaten them, the court will never give me bail. Similarly, if the department feels that it is necessary for the delinquent employee to be kept out of the department till the time this inquiry is pending, then they will place me under suspension. This is the correct use of the power of suspension which is provided in the rules. However, it is vastly misused, and as lawyers, we therefore come to the court and we challenge the orders of suspension, we get them set aside, we get the employee reinstated. So that we do, but it does happen that the power of suspension is misused. So one is an express order of suspension passed by the employer. There's another kind of suspension. This is very interesting, it's also provided in the rules. So friends, for instance, let's assume that a person, a public servant, is named in an FIR under Prevention of Corruption Act, and the Vigilance Bureau raids his house, picks him up and puts him in custody. So he's in custody. Now he engages a lawyer, it takes time for him to get his bail. So he is in custody for more than 48 hours now. So he will be missing from his department. The department is informed that this person has been picked up by the police. So here comes the concept of deemed suspension. Now what is deemed suspension? Deemed suspension is very simple. When a public servant is in custody for more than 48 hours. Now this depends on the service rules that we are relying upon. Usually it is 48 hours. So when a person is in custody for more than 48 hours, he will be automatically placed under suspension. There's nothing to be considered. Just his being in custody for more than 48 hours is a good ground for putting him under suspension. This is very important. Now, last thing about suspension that I would like to discuss is that how long can it go on for? So, for example, the departmental inquiry takes, say, 1 year. Now, in the present time, especially in the COVID times, the departments are not working due to social distancing, things are not working out. So it may take 2 years for a department to carry out the departmental inquiry, serve a charge sheet, etc. What will happen to the employee who is placed under suspension? So there's a safeguard in the rules, and the safeguard is that if the suspension period exceeds 3 months, then that person has to be reinstated if no disciplinary inquiry has started. So for instance, 3 months period is over, no charge sheet has been served yet, he is yet under suspension, he will be reinstated by law. And if the departmental proceedings are initiated, then of course the suspension can be extended. This is provided in the rules. 1. And lastly, for instance, if a person is undergoing a criminal trial, a public servant is undergoing a criminal trial, in that case, until and unless the trial is over and he is exonerated, because if he's convicted, then matter ends. If he is exonerated, until and unless that time comes, he will continue to remain under suspension. There could be a slide here and there in the relevant service rules, but this is the general proposition of law, which is consistent in most of the rules, regardless whether it is union's rule or state's rule. So, now since I've just touched upon the issue of a person being subjected to a criminal trial, a public servant being subjected to a criminal trial, and also departmental proceedings. A very, very vital question. I will be concluding my session with this. A very, very vital question that would come to your mind is that what if the public servant is acquitted in the trial, which was going on since, say, long time, and in the meanwhile, during the pendency of the trial, he is terminated from service, whether he will be reinstated or not. So here I am reminded of a wonderful judgment by the Honorable Supreme Court that I read back in the day when I was a college student. So that's why I have included it in my keynote. So what happens is that acquittals are of two types. One acquittal is an honorable acquittal, which is given to you by considering all the witnesses, all the statements, etc. And other acquittal is which is merely given to you on benefit of doubt. So one might be able to, pay off the witnesses, and witnesses would turn hostile. So one would get benefit of doubt, and he would certainly get acquitted. So here I am reminded of an army officer's case that I read back in the college days, where the army officer was accused of killing his wife, but in the trial he was acquitted on benefit of doubt. So he moved to the court seeking reinstatement in service. The army rejected his claim for reinstatement, and therefore this matter was being contested in the courts. So what happened? The Honorable Supreme Court, the matter went up to the Honorable Supreme Court. The Honorable Supreme Court said that there is a distinction between honorable acquittal and acquittal on benefit of doubt. Now this army officer had got an acquittal on the benefit of doubt. So therefore the Supreme Court said that it is not wise, it is not viable to reinstate him into service because he has not got an honorable acquittal, that is acquittal on merits. So this is something which is very, very important that I wanted to discuss in the end. So by stating this judgment, I would like to conclude today's keynote by just quickly doing a recap of whatever we have discussed today. So firstly, we discussed what are service laws, how are they different than any contract of employment. Then we discussed what is the need for holding departmental inquiries. Then we also discussed Article 311 of the Constitution of India, which provides that departmental inquiries must be conducted if an employee is proposed to be dismissed, removed, or terminated from service. Then we have discussed the 6 stages of departmental inquiries and also the power of suspension. So in sum and substance, for you as college students and the respected faculty members, I'm sure this would leave you thinking and would help, would make you read further upon the details and judgments of which are pertinent to the service law and departmental proceedings, because service law is a very, very emerging field. I mean, it has emerged a lot already and it's still growing because the governments, they are making appointments, people are being appointed, people commit irregularities, and public servants, they are committing irregularities, under political pressure or by mistake. So the departmental proceedings have to go on. Just like criminal cases, the officers, public servants are going to commit errors, and therefore this is for the students, it can be a good field of law to pursue their careers in if they want to pursue litigation. And even for students who want to pursue their careers in, say, civil services, this field of law will be helpful because as senior officers, you never know in the coming times, some of the students who get selected in civil services, they might get appointed as inquiry officers to hold these departmental inquiries. So even for lawyers, students who want to become lawyers or students who want to become civil servants, for both of them, having some knowledge about departmental inquiries and service law is a must. So I hope I have been able to set up a good basis for everybody to keep, to start working on this if they are interested with it. And I'm always available to help anybody with this topic or anything else that is required to be done in the course of time. Thank you so much. It was a pleasure delivering my keynote before this August gathering.
Thank you so much, sir.
And the house is open for questions because I don't want it to be a monologue. I want it to be a dialogue. So I'm open for questions and I would love to answer queries if anybody has them.
Thank you so much, sir, for the session. With your due permission, maybe we can proceed with the concluding session.
Please.
Thank you so much, sir. On the behalf of Department of Law, Government Mahindra College, and the entire fraternity of the institution, I would like to extend my most sincere thanks to the Almighty God for making today's event a resounding success. With His blessings and grace, we are able to make this event a grand success. On the behalf of my department, I extend a hearty vote of thanks to our esteemed keynote speaker, Shri Gurnoor Singh Sandhu, for sparing his valuable time from his busy schedule to grace today's occasion. Sir, today we had an opportunity to listen to your inspiring words, which are surely going to encourage us in future events also. I need to express my deepest sense of appreciation for the elegant style of explanation of the topic. Your thoughts have not only enlightened our minds but have also shown us a new path. A special mention to our respected principal ma'am, Dr. Simrat Kaur, for being the catalyst that stimulated us to do our best and as a standard pillars of STEM. With a deep sense of appreciation, I would like to thank HOD Department of Law, Dr. Joginder Paul, for his untiring efforts. Our sincere sense of gratitude to teacher in charge Dr. Sanjeev Mehta for being rock solid support system and source of encouragement for us all. I would also like to extend my thanks to the revered faculty members of Department of Law for their enormous cooperation during organizing this event. Once again, my warm regards and hearty thanks to each and everyone who has been a part and parcel of this competition and event. I would like to conclude with the following lines. At the times when our own light goes out, it is rekindled by a spark from another person. Each of us has a cause to think with deep gratitude of those who have lightened the flame with us. With a deep sense of gratitude, again, I would like to thank everyone for being the part of this event. Thank you so much. With this, I would like to conclude the session. Thank you.